And here we have, going to come back to the Shipley and Warren matter. So Mr. Piccarelli, if you want to come up, and then Mr. Shipley and Ms. Warren. These are cause numbers 24-2226 and 24-2126. And then Mr. Piccarelli, I guess procedurally, there were some responsive declarations filed. Have you seen those?
I've seen one motion to dismiss filed.
Okay, so there was also both Ms. Warren and Mr. Shipley filed declarations with multiple exhibits. Were you providing copies of these?
I'm not aware of anything from Warren. No, I got, like I said, a motion to dismiss from Shipley. That's it.
So since our last hearing, the only thing you've gotten is a one-page motion to dismiss.
No, sir. It was inclusive of other documents, but it was attached to the motion.
Okay. Did you folks serve him with copies of the declarations that you filed? I think it was on the 19th?
Yes.
Yes. Can I see what you have, Mr. Piccarelli, please?
Yes.
If you can hand that to the bailiff. Is this the extent of what you've gotten, Mr. Piccarelli?
Yes, Your Honor.
Okay. So both of you filed these. Do you recall doing that?
Yes.
I don't see that there's proof that Mr. Piccarelli has gotten this filing. This was done on the 19th. Do you have anything that has a cover sheet like this, Mr. Piccarelli?
Yes, Your Honor.
Can I?
You can see both.
Okay, so you do have those. Okay, all right.
Yeah, I just had the.
Okay, sorry. Okay, so the motion to dismiss. Done all that. Okay. All right, so I'll hand this back to Mr. Piccarelli. Okay. So I guess the first procedural issue we have to address is whether or not Mr. Piccarelli is able to bring this action based on this motion to dismiss. So because they were the ones that filed it, I'll hear from them, give you an opportunity to respond, Mr. Piccarelli. So Ms. Warren or Mr. Shipley, what would you like me to consider as far as dismissal?
That he's not living in the town of Ione, therefore he cannot legally be on the council or even bring like this forward.
Mm-hmm.
And we had all the evidence there of where he actually does live up in Medellin Falls at the Oreille Apartments.
Okay.
And that where he claimed to live in Ione, there has not been anybody living in that residence at all.
Okay. Mr. Shipley, anything that you'd like to add on that front?
Yes, sir. My understanding is that the sheriff gets an address in order to serve a person from their driver's license or something, and he's been served several times in Medellin Falls. Not Ione.
Okay. And so Mr. Piccarelli, what can you tell me about this situation here?
Okay, so I think there may be some misunderstanding. Under RCW 29A 56110, it's very, very clear who can bring a recall petition and who can't.
Correct.
So I am a legal voter in the state of Washington.
Yes,
currently
sir.
active, and also in the town of Ione. And so that's the only point that's actually pertinent to that argument there. Because they have no proof saying that I'm not a registered voter, which I am.
Okay,
They haven't submitted any facts at all. What has been submitted is all allegations. There's nothing to support any of it.
well, but are you a resident of the city of Ione?
I am registered, yes, sir.
No, that's not the question. Are you a resident of the city of Ione?
Yes, I am.
And what verification or I guess there's nothing in the file that actually establishes that.
It's with the auditor's office for my voter's registration.
Okay, so what I guess evidence do we have? Because all the evidence I'll tell you points to the contrary conclusion that you're not a resident of the city of Ione.
What evidence is that, Your Honor? Because I don't see any evidence whatsoever.
In your petition, you provided a PO box for service in the town of Medellin Falls.
That is correct.
All of the service that's occurred in this case has occurred in a residential address in the city of Medellin Falls. And the information that has been provided in support of the motion to dismiss is that the property that you claim to live in Ione is a vacant building.
Again, okay, so if I may, Your Honor?
Yeah, absolutely.
Okay, so as far as the process of service, that doesn't say anything about residency. Basically, all that's saying is where the individual was served at that particular time in that location. It's not a confirmation of residence or anything like that. So I think that point is null and void. If that were the case, one of the affidavits say I was served in unit number 2, the other one number 27. So I'd have to live in both of those according to that theory. I was also served outside of that building. I was also served downtown. So I'd have 4 different residences if we're going off that hypothesis. Does that make sense? And so that's null and void. And as far as I'm concerned, that has no merit. As far as the pictures of the 804 residents, okay, so it says, according to the petition, these are allegations are going to be heard on the 7th of February. From the auditor's office, but we'll go ahead and address them now, right?
No. Is there a hearing pending?
Yes, sir. There is a hearing to decide whether or not these allegations are true and correct. And thus far, they haven't been proven by the auditor at all. We haven't even had that hearing.
Oh, but there is a hearing to determine your status of.
Yes, sir.
And that has been called into question.
Yeah, because as soon as somebody files any type of challenge, there has to be a hearing on it, regardless.
Okay. All right. So, and that's not actually that far off into the future. So at this point in time, I believe there are legitimate questions about whether or not you have standing to bring this matter. And being that the hearing is here in just a few weeks, what I will do is I will continue this out past that date to determine what, if any, resolution is made at that hearing, which is the 7th. And we can have a hearing as soon as the 8th to have this resolved. And if it's determined that you lack standing, then that'll be dispositive of this. But if that is, especially since there's an ongoing challenge, and Mr. Slavin, is your office involved in that? A little bit ambitious?
Yes, sir.
Okay. So that would put us out to the 15th. Mr. Piccarelli, are you able to be here on the 15th?
Yes, Your Honor.
And Ms. Warren, are you able to be here on the 15th?
Yes, Your Honor.
And Mr. Shipley?
Yes.
Okay, and I apologize for this, but I know this is kind of a dynamic situation. This is all, some of this information that was provided very recently to myself. And especially if there's collateral proceedings that are going to be potentially dispositive of this, I think it is my obligation to allow those to go through. So I'll prepare an order that moves both of these over to 15th of February. And that is again going to be with myself, so I'm not pawning this off on any other judicial officers.
And Your Honor, just for clarity, I thought that we were going to have these cases tried separately, and yet we still have both the respondents sitting together, both of their affidavits mirror one another. So it seems like it's the same case being heard at the same time, even though they have separate numbers. And so if I can get some clarification, that'd be great. Thank you.
Is there a need to do separate hearings? Or
Yes, sir, there is.
Why?
Because each case is separate.
But all the allegations, the facts, everything is the same.
The facts may be the same, or they may be having the same argument, but they're separate cases. But if this, I don't want to argue.
No. I'm not going to consolidate these into one matter, but I don't see.
But it seems as though that's what's happening here, and I just wanted to make that clear for the record.
Well, no, and that's fine. But I guess would we not be holding the exact same hearing twice if we did these separately back to back?
Yeah, you would have one hearing and then you'd have another hearing. One hearing per case. That is correct. Instead of having them both there together, collaborating their answers and their affidavits.
Well, but I can't control what they do outside of this courtroom, and it seems like the information they're presenting is the same. So I don't see the utility of having you sit here, Ms. Warren, Mr. Shipley there, hearing the exact same arguments twice in a row. I mean, if you can identify a procedural reason we need to do that, I'll entertain that. But other than that, I mean, if they want to just write out identical affidavits and file that, and they
And then sit together in the same hearing. So you'd have,
No, you're fine. No, go ahead. Go ahead.
well, it would be like having two separate criminal, not that this is criminal, this is civil, but having two separate criminal cases and then having them both the defendants sit together. And then that's good to know. Thank you, Your Honor.
No, I mean, we have joint trials, joint hearings. I mean, I recently did a case here where I had 6 different parties all at the same time. So, I mean, this is not some sort of anomaly or anything unusual. In fact, a lot of the case law on this issue has involved multiple challenges and recall petitions that have all gone up together. There's multiple cases that talk about situations where entire city councils unanimously and together go up on appeal and have these hearings done simultaneously. So this is nothing abnormal that's being done here. Okay, so we'll go out to the 15th. Okay, so this is for Ms. Warren's matter. And again, Mr. Piccarelli, if you're able to find a procedural basis to do these separately, I mean, I'll hear you out, but for purposes of judicial economy, I just think it makes sense to do them all at the same time.
Yes, sir. And I'll file something later.
All right. All right, so I will see everybody back in a few weeks. All right, thank you, folks.